Dictation will start in 5 seconds. Start. The challenge by the appellant is threefold. Firstly, it is contended that prior to the respondent bank acquiring the said property in an auction sale, the same had been re-entered by the Land and Development Office of the Government of India, being the lessor of the land underneath the property, and thus no title was acquired by the respondent bank, and the said property was not public premises within the meaning of section 2 subsection E of the PP Act, for the state officer of the respondent bank to pass an order with respect thereto. Secondly, it is contended that no bona fide requirement on which ground the appellant was sought to be evicted had been established, and rather it stood admitted that the eviction of the appellant was with profit motive. Full stop. Lastly, it is contended that no proper opportunity to lead evidence was given to the appellant by the state officer of the respondent bank. As far as the first of the challenge aforesaid is concerned, the admitted position is that when the respondent bank, after bidding for the said property in an auction, had applied to the court for confirmation of the sale in its favor, the L&DO had objected on the ground that the property having already been re-entered, no title could be conveyed to the respondent bank. The said application of the L&DO was rejected, giving liberty to the L&DO to seek its remedies. Not only so, the Supreme Court in Shanti Sharma versus Ved Prabha on 93 has held that re-entry effected by the L&DO of lease with respect to the land underneath the property does not prevent the lease of the said land from seeking eviction of his her its tenant in the property constructed on the said land as owner thereof. It was held that unless the L&DO pursuant to the said re-entry repossess the property, the lease of the land is fully entitled to deal with the tenants inducted in the property constructed over the said land as owner, landlord, and the tenants of the lease cannot challenge the title of their landlord. Upon the senior counsel for the appellant being confronted with the said judgment, he had no reply thereto. Now, therefore, it has to go by the earlier decision of the court, which has decided that matter justifiably as such. Done.